All right, good morning. Welcome to the 294th District Court. My name is Judge Chris Martin. I'm going to call this morning's docket. However, before I do so, make sure that you maintain social distancing in this courtroom. As I look out, I see some of you wearing masks, some of you are not. If you would like a mask and do not have one, one can be provided for you. Also, please make use of the entire space of the courtroom. I want you to spread out as much as possible unless you are with your family unit, okay? And be aware when you're walking in the hallways, in the restroom, the elevators, stairwells, that you maintain social distancing as much as you can. All right, when I call your name, please say here or present and raise your hand so I can acknowledge you for the docket. Eric Atkinson. Thank you, sir. Marcus Gardner. Roderick Hunter. Melba Kennedy. Dylan Kohler. Wendy Ledoux. Gennaro Laredo Trejo. Tanya McBride. Xavier Pitts. Xavier Alexander Pitts. Do not see Mr. Pitts in the courtroom or on Zoom. Coleman Raspberry. Priscilla Rosales. Stephen Slayton. Chad Thomas. John Davis. Justin Grubbs. Justin Richard Grubbs. Do not see Mr. Grubbs in the courtroom, nor is he appearing on Zoom. Jesse Henry. Jesse Wagner Henry. Mr. Henry does not appear in the courtroom or online. Rachel Hicks. Joshua Bailey. Zion Thomas. Stephen Gandy. Mr. Gandy here, Mr. Elliott. John Chadwick is appearing online with counsel. Aurora Halamka. Kenneth Stanley. I believe that Ms. Millentree filed a waiver of arraignment on Mr. Stanley's case. However, I believe it was rejected and refiled this morning. So we anticipate a waiver being approved on that. Katie Lee or Lay? Is it Lee? I see. Is it Lee or Lay? Lay. Antonio Lano. I believe that he is appearing via Zoom. Thank you. Dustin Sorrells. Is it Sorrells or Sorrells? Sorrells. Okay. All right. Is there anyone's name that I have not called that's present in the courtroom? You're present in the courtroom on today's docket, and I have not called your name. Signature.
What I'm going to do on these signs, I'm going to wait until I call the case and then after I'm going to just come back to you. What I do is I don't know what I'm doing.
All right, counsel, do we have anyone that's ready?
I have
Mr. Mr. White? Who are you ready on? Mr. Sorrells, if you'll approach the podium, please. This is CR 20-90, State versus Dustin Sorrells. I believe we're set for pretrial today.
Yes, we were set for pretrial yesterday. I had been contacted with Tyler. We were trying to get a video. The state provided it to us yesterday. I'm going to be back up here on the 13th of October. I just asked for what you said that day.
Ms. Heisel, any objection? And I believe you're muted.
No objection from the state, Your Honor. I would just say it's very hard to hear defense counsel.
Okay. You're requesting a resetting until October 13th. Is that correct, Mr. White?
Yes, sir. That'll be next day. I think I'm back here. So.
All right. Court sets Mr. Sorrells for pretrial at 9 a.m. on October 13th. Once Mr. Sorrells receives the notice of setting, he'll get the yellow copy and the court gets the white copy.
Yes, sir.
Mr. Ugler, did I see you swivel around in your chair when I said, is anyone ready? I thought so.
Good morning, Your Honor. This is set for final docket call. The state has conveyed an offer to Mr. Chadwick. We have turned down that offer and we'll need a trial setting.
Okay.
Discovery is complete.
All right. And Mr. Ugler, what was the offer in the case that your client has rejected?
It was for penitentiary time, Your Honor.
Okay. 4 years or just 4?
For a term of years.
For a term of years. Okay. All right. All right. And Mr. Chadwick understands that once we move past docket call, the court may not entertain a plea agreement.
He does, Your Honor. I've covered that with him.
All right. Thank you, Mr. Ugler. Okay. The court will set Mr. Chadwick for jury selection on October 26th. At that time, Mr. Chadwick, you are to appear in person in the basement of the courthouse. And at that time, court staff will be there to assist you with the necessary paperwork to give you your new court date. Your attorney, Mr. Ugler, will not be in court with you that day unless he so chooses. Otherwise, he'll be notified when your court is liable for trial. Okay? So, Mr. Chadwick, since you've appeared via Zoom, this will be the only notice you receive from the court. All right? So, October 26th at 9 a.m. in the basement of the courthouse. All right, Mr. Chadwick.
Your Honor.
You're welcome, Mr. Ugler. Mr. Chadwick, you're free to go. Mr. Ugler, anyone else on this morning's docket?
No, sir. That's all.
All right. Thank you, Mr. Ugler. Good to see you.
Have a great day.
You too.
Judge, we're ready as well.
Mr. Biggs, if you're ready. So 620-71, State versus Joshua Dan Bailey. Mr. Bailey has made his way to the podium. Record will reflect that counsel for Mr. Bailey's appearing via Zoom and Mr. Bailey's appeared in the courtroom today. I believe that we're set for docket call today, Mr. Biggs.
Yes, sir.
And have you received all your discovery and a plea offer from the state?
I believe we have, Your Honor.
Okay. And is there any plea agreement that's going to be reached in this case, or are we requesting a jury or a bench trial?
You know, at this point, Judge, I believe we request a jury trial.
And does Mr. Bailey understand that once we pass docket call today, even if the state makes a better offer, the court may not entertain a plea agreement?
He does, Your Honor.
Okay. All right. Mr. Bailey then is set for jury selection on October 26th at 9 a.m. And just like I informed the individual before you, you're to appear at the Van Zandt County Courthouse in the basement. And down there, the court staff will be there to assist you with paperwork for your new court date. And Mr. Bailey, what will happen is you'll appear every month on a notice of jury selection setting until your case is reached for trial. Okay. Now, Mr. Biggs is not going to be required to be here. He can be here if he so chooses, but he's not going to be required to be here until he receives notification from the court that your case is in the top 10 cases or those cases that are selected for trial. No, on October 26th. I'm going to give you a notice of setting form right here with that date on there, and you're to be back on that date. All right, Mr. Biggs, anything further?
Not this time, Your Honor.
All right, thank you, Mr. Biggs. You can be excused.
Thank you.
Have a good day. Mr. Stuckel, are you ready on Antonio Lano? I believe that you're muted. You're going to have to unmute yourself.
Can you hear me now, sir?
Yes, sir, I can hear you. Good morning.
Good morning, Judge. How are you?
Good. Are you ready on CR 2134 Antonio Lano?
I am ready for today's proceeding. We are asking for a reset for additional discovery.
Okay. What's the discovery that you lack?
I've just received a notice from the state on Wednesday, the 16th, that there is some media and videos available on this case that I don't have yet, and they're requesting a flash drive to copy that for me, and we were going to be providing the state with that.
Okay, give me just one moment here. I need to review one thing in the case. Okay, and so Mr. Stuckel, you said that you received an email on Wednesday about the media. Is that the first time you've been noticed about discovery being available on the case?
It's not the first time I have the remainder of the discovery. That is the first indication I had that there were apparently videos available.
Ms. Heisel, is there any notification in the discovery portal on cases as to whether or not there's digital evidence available? My concern is that we were set for arraignment on August 6th. And so there was a waiver filed and granted. And so we've had over 30 days, about 40 days between the two. So I need to determine whether or not the defense attorneys are on notice to request that, or so that we're not losing 30 and 40 days between settings.
Thank you, Judge. For some reason, it wasn't letting me in. And it usually says, 3 CDs or whatever. I'm not sure if that's being seen by defense counsel. I do know in this particular case, Miss Abney has just been waiting on those videos. She has been trying to pull the docket and make those copies ahead of time. But she had sent out notice that we didn't have any CDs available to burn these particular videos.
I know at one time a policy letter, I believe, by Ms. Curry regarding how counsel is to obtain those records if CDs or DVDs are needed. Is that still is that in use in the new discovery portal?
I believe so, Judge. I'm not familiar with what the new portal looks like for defense counsel, but it's our understanding that if there are DVDs needed, that is viewable from their side.
Okay. All right, that's my only concern is that we've had 40 days since arraignment to obtain evidence and then file our pretrial motion. So I'm going to give another reset in this case for pretrial, but that's something I definitely want to make sure doesn't happen in every case. Otherwise, everyone's losing time, state, court, and defense. All right, so Mr. Stuckel, the court will reset Mr. Lano for pretrial hearing on Thursday, October 15th. Do you have any scheduling issues on that day?
Let me check real quick, Judge. You said Thursday, the 15th?
Yes, sir.
I have a matter in the afternoon. In the morning, I'm clear.
Okay, then we'll set this for 9 a.m. on Thursday, October 15th. And I would just ask that you follow up with your email instructions on getting that discovery that you need and then having your pretrial motions filed at least 7 days prior to that setting, according to.
All right, my motions are filed, Judge, but I will follow up on the videos.
Okay. Well, when you say your motions are filed, so you filed a motion to suppress?
No, I've filed some pretty standard pretrial motions. The only one that could require some time would be the motion for CPS records. Child Protective Services was involved in this case. They're fact witnesses and did a joint investigation with law enforcement. We do have a partial report from CPS that's been provided through discovery, but I've worked with CPS for many years. I know that there's much more than what's been provided.
Okay. All right, then I guess if we don't have all of those records or you don't have all of your discovery by the 15th, you'll let me know and we'll take it up then.
Yes, sir.
All right, so Mr. Lano, this will be the only notice you receive from the court that your next hearing is October 15th at 9 a.m. and I'll grant you permission to appear via Zoom if you so desire. All right.
Yes, sir.
All right, if there's nothing further, Mr. Stuckel, then we'll be adjourned in this case.
All right. Thank you, sir.
All right, thank you. All right, counsel, we have anyone else that's ready? Not this time. Ms. Payne, you're not ready either? Do you need? You are ready? CR 2132, State versus Katie Lay. Ms. Lay, if you'll make your way to the podium, please. All right, Ms. Payne, I believe that Ms. Lay is set for pretrial today.
Yes, we have an agreed plea in this case, it's a pretrial intervention contract that's been executed by myself and my client. We just need the DA to sign it, and my client needs to pay her fee before it can be entered.
Okay. Do you, Ms. Heisel, do you want Ms. Payne and her client to come to your office to do that? Yeah, and I don't know why. Let's see. I don't mute you.
Judge, it's completely their preference. If they want to come get a signature, we can do that. If not, I can drop by the courthouse later today and sign off on that if you want to go ahead and hear it now.
Let's have her, I'm going to have her go to the DA's office. She can go ahead and pay her fee and get the signature, and then you can bring it back.
Okay,
So you're free to leave, to go to the DA's office, take care of that business, and then come back. And when she's back, let me know, Ms. Payne, and we'll get her in.
yes, Your Honor, thank you.
Ms. Heisel, try to unmute yourself again. All right, see, so when you mute yourself, let me see, I need to. There must be a setting on that says that you're not allowed to unmute yourself. Now we have it. Try it now.
That fixed it, Judge.
Okay. All right, Mr. Elliott, Mr. Gandy. Is Mr. Gandy here?
He's on his way.
He's on his way.
I'll just call him.
Okay. Is Miss Dixon here? I saw her earlier. She's not here.
Judge, Miss Dixon has been texting me, so I suspect she might be in the hallway trying to communicate about her case.
Okay. All right, there's several of you that are on the docket that do not have attorneys. Before I call you up, if it is your intention to request a court-appointed attorney because you feel that you are indigent and you cannot afford an attorney and you want an attorney to represent you and you have not done the paperwork, then what you should do is exit the courtroom at this time and go down to the end of the hall on the left and speak with the indigent defense coordinator, Patty Taberham. If that applies to you at this time, I want you to stand up and exit. And that means the rest of you that I'm going to call up are going to tell me that you're going to hire an attorney. It's one or the other. You're either going to request court-appointed attorney or you're going to hire an attorney. If you've already filled out the paperwork, then you're fine. But if you haven't done one or the other, if you haven't filled out the paperwork and you're not going to hire an attorney, then when I call you up, you're going to have to surprise me as to what the third option is. Okay? Eric Atkinson. This is CR 20147. Mr. Atkinson, you're set for arraignment on possession of controlled substance, penalty group 1, less than 1 gram. Are you going to hire an attorney to represent you? Have you filled out the paperwork? You have? And have you received any notification from Ms. Abraham? All right, go ahead and have a seat. Raise your hand if you are going to hire an attorney to represent you. Keep them up. All right, if you raise your hand, then move over to this side of the courtroom for me. Come up to the first 3 or 4 rows and spread out there as much as you can. Ma'am, come on up, right there at the podium. What's your name? Yes, ma'am. Wendy? Ledoux. All right, Miss Ledoux, this is CR 20173-174. You're set for arraignment on a false statement regarding property or credit, 3rd-degree felonies. So, Ms. Ledoux, you are going to hire an attorney to represent you? Yes. And do you know who you're going to hire? Yes. Who are you going to hire? And have you retained him or hired him at this time? Yes. Have you already paid him? I'm making payments. And how many payments have you made and how many payments do you have to make? I don't know. Well, how much do you owe in total? You're just going to make payments forever? Probably. You don't. So he didn't tell you how much he's going to charge you to represent you? There's Mr. Calabria. Mr. Calabria, we were about to make you a lot of money. Mr. Calabria, do you need some time to speak with your client and I can recall the case? Yes, sir. Okay. Prosecutors appearing via Zoom this morning, so you probably make a phone call, I'm assuming. Okay. But I'll recall your case. All right. Sir, your name? Come on up to the podium. All right, this is cause number CR 20194, State versus Stephen Kyle Slayton. You're set for arraignment today for theft of property. And who are you going to hire, Mr. Slayton? Are you going to have the funds available to hire an attorney, you believe? All right, Mr. Slayton, what I'm going to do is I'm going to reset your case till October 15th for arraignment and also a status for you to hire your attorney. That'll be set at 9 a.m. My bailiff is going to give you a notice of setting form that you're to sign, and then we're going to give you a copy of that. And you're to be back on October 15th at 9 a.m. with your attorney. No. And Mr. Slayton, stay right there with me. Just go ahead and have a seat there for just a moment. I'm gonna give him a copy and then I'll leave that original. Thank you. All right, Mr. Slayton, go ahead and stand back up at the podium. Mr. Slayton, I believe you were arrested outside of Van Zandt County. Is that correct? I'm going to give you, my bailiff's going to give you a copy of a processing order. And what I'm going to order you to do is when you leave, I need you to go to the Van Zandt County Justice Center, which is on Highway 64 West. Look this way. Okay, I'm telling you exactly what you need to know. Go west on Highway 64 when you get past the intersection of Highway 859 and 64, past the red light, be about half a mile on your right. The Justice Center is there. I need you to go in there and take this order with you. And what they're going to do is they're going to come in and they're just going to fingerprint you. They're not going to hold you. They're not going to arrest you. They're going to fingerprint you so that the state of Texas can get a tracking number for your arrest that we're required to do. Okay. So you just show them this. They're going to have you sit there for a second. They're going to take you back. They're not going to change you out, do anything like that. They're going to bring you back, fingerprint you, and let you go. They're not going to keep you. No, you'll see right there on this order. It tells them there at the very bottom to process you expediently as practical to minimize disruption to your liberty and freedom. So they're not going to keep you. All right. Unless you have other warrants. You got other warrants or something else going on. That's they may keep you. Okay. All right. So go ahead and take care of that before you leave town. All right, ma'am. Next. Your name? Kennedy. CR 20171, State versus Melba Renee Kennedy. Ms. Kennedy, you're set for arraignment for possession of a controlled substance. And Ms. Kennedy, who are you going to hire to represent you? Do you know? How long is it going to take you to hire an attorney? Okay. All right. I will reset you to October 15th as well for arraignment and status to hire your attorney. That'll be at 9 a.m. Once the bailiff provides you with this notice, sign that. When you receive the yellow copy, you'll be free to go. It's okay. Yeah, I know. It's a lot today. I think I sent 2 more your way. Okay. Okay, it's running late. Blink out right there. All right, sir, on the left. No, in the front row, left. Okay. Sir, you in the gray on the right, are you here to assist with? Okay, all right. And what's his name? All right, this is CR 20177, Mr. Laredo. And Mr. Laredo is set for arraignment today for failure to comply with sex offender registration. Is Mr. Laredo going to hire an attorney to represent himself? Okay, has he requested a court-appointed attorney? Has he filled out the paperwork? He has filled out the paperwork? And if he's filled out the paperwork, then he can have a seat. Now, he's filled out paperwork today with my, and 2 pages regarding what his income is and his expenses. Okay, all right, then you can have a seat over here. That's fine. Next, sir, you're on the right. Your name, sir? You said John Davis? Okay, you have an attorney. Mr. Casey Ashmore is your attorney. Okay, he's on his way. All right, so have a seat. Sir? Your name? Marcus Gardner. All right, this is CR 20161 and 162, State versus Marcus Dwayne Gardner. You're set for arraignment on 3rd-degree felony, unlawful possession of firearm by felon, and driving while intoxicated 3rd or more. And Mr. Gardner, are you going to hire an attorney to represent you? And do you know who you're going to hire? You're going to hire Mr. White. Have you spoken to Mr. White yet? When's the last time you spoke with him about your case? Okay, and have you retained him yet? How much time is left before he's able to represent you? I might not be able to give you 6 weeks. I can't let our case wait on whether or not you get the money to hire an attorney, because otherwise you could just say, I'm never going to be able to hire him, and your case would never go to trial. How many, you've been here before, haven't you? How many times have we reset your case to hire an attorney? All right, and Mr. Gardner, that case is in the lower court, right, in the county court of law? And you're coming back on the 30th? What I'm gonna do for you, Mr. Gardner, is I'm gonna set you on October 15th, but I expect you to have Mr. White or some other attorney here with you that day. Okay? So I'm gonna set you for arraignment and status to hire that attorney on October 15th. Mr. Manning, are you ready? CR 2190 Coleman Raspberry. All right, you are Coleman Thomas Raspberry, is that correct? All right, Mr. Raspberry, you've applied for a court-appointed attorney. The court has reviewed your application, finds that you are indigent. Court has appointed the Honorable Jonathan Manning to represent you. Mr. Manning, Mr. Raspberry is set for arraignment today. Have you had an opportunity to review the indictment with him?
We have, Judge, already.
Go ahead.
Judge, at this time, Mr. Raspberry's name is spelled correctly. We understand the charge being submitted by community or plea not.
All right, the court will enter Mr. Raspberry's plea of not guilty into the record, and we'll set this for pre-trial on October 20th at 9 a.m. And Mr. Raspberry has completed his conditions of pretrial release, has he not? Have you seen those?
I don't believe he's been given those at this point.
Okay, then I'll have you come over here and sit in the jury box after you receive your yellow notice here. And Officer Matura will have you sign your conditions. Mr. Clavier, are you ready?
Yes, sir.
Ms. Ledoux, okay, this is CR 2174, CR 2173. And Mr. Claveria, are you representing Ms. Ledoux?
Yes, sir.
Okay, all right, we're set for arraignment in both of her cases today. Have you had an opportunity to review the indictment?
I had, Your Honor, waiting for
Yes, that's granted. Is her name spelled correctly?
Yes,
And she understands what she's been charged with?
she does.
And her plea?
Not good.
All right, court will enter Ms. Ledoux's plea of not guilty into the record in each cause. We'll set this for pretrial hearing on October 20th. Do you have any scheduling conflicts that day, Mr. Clavier? It's a Tuesday.
No, Your Honor.
Okay, we'll set that at 9 a.m. And Mr. Calabria, I'm going to order your client to go out to the sheriff's office and conduct some TRN processing. She was arrested out of county, and so the state needs to get a tracking number issued here in Van Zandt County. So I'm going to have these issued to the clerk and get you a copy. And Ms. Ledoux, I'm going to order you to go, upon leaving court, to go out to the Van Zandt County Justice Center, present these, and they're going to take you back and they're going to fingerprint you and they're going to let you go. It's just an administrative thing we have to do for the state. Okay? All right. So go ahead and have a seat and we'll bring these to you and then you'll be free to go. Okay? Yes. Thank you, Mr. Calabria. Good to see you. Mr. Elliott, are you ready? Mr. Gandy, if you'll make your way to the podium. This is CR 2120, State versus Stephen Paul Gandy. I believe that we're set for pretrial today. Any contested pretrial motions, Mr. Elliott?
No, we sent emails overnight in July. Ultimately, early August, we received 3 discs. The first one we put in, we attempted to download, it said it would take 11 hours, froze in the middle, so I'm going to be able to go back and find out why their disc is not working. And it may be my fault, because this is the first time that I've probably downloaded their discs. So I need to at least figure out what program I need to do on my computer or something. Figure it out.
Okay. Any objection from the state?
No, Your Honor.
Okay. All right. Court will reset this for pretrial on October 15th. Do you have any scheduling issues that day, Mr. Elliott? While Mr. Elliott's looking at that, Ms. Heisel, do you know if there's a preferred program that your office uses to view the digital evidence?
Judge, I think it just kind of depends on the format of the video. Different agencies use different systems. I personally usually like to use Windows Media, but there are certain programs that play better through VLC.
Okay. Mr. Elliott, what do you use? Do you know what kind of software you use?
I personally can't figure out how to do it, and I know that the office hasn't figured out how to do it, so I don't, if I do, I promise I'd say, I really don't know.
And if Mr. Elliott will just contact us, we can always set up to play videos here in the office for anybody.
Do that, but I would prefer to go over there and have it figured out so I can continue to let my clients in the office. Pre-trial?
Pretrial on the 15th. Yes, you may. Mr. Candy, we'll see you back on October 15th at 9 a.m. You're free to go. All right. Yeah. Back to the clerk. Okay. And not to give this to the defendant, or are they getting a copy?
Okay, Raspberry. Raspberry has his docket with Jonathan.
Yeah, okay.
Silas and Culver.
Okay. Who's the original? Are they here? No. Okay, all right, I'll give that to them. All right, so these are mine to give to them. Okay. Okay. You're gonna write needs interpreter on there, is that what you said? Yes, yes. Ms. Dixon, are you ready? Mr. Thomas, if you'll make your way to the podium, please, sir. CR 1876, State versus Zion Thomas, except for MTA today. Ms. Dixon?
That's correct, Your Honor. We had an opportunity to communicate with Ms. Heisel on behalf of the District Attorney's Office. What we're asking the court is to set this for October the 6th, at which time my client will be prepared to enter into jail if he has not finished all of his community service and met his requirements. And we have reached and discussed an actual resolution that would involve adjudication and punishment.
Okay. Court will set Mr. Thomas then for MTA on, or MTA plea of true on October 6th.
It's my understanding that that was the day that was originally set aside for evidentiary hearings, that the court could pass here.
Yes, yes. And we'll set that at 9 a.m. All right.
Thank you, Your Honor.
You're welcome.
And that concludes my business. Thank you.
You may. Yes, he gets the yellow copy. We retain the white copy. All right, Ms. Payne, are you ready with your client?
Yes, Your Honor.
Ms. Lay? Ms. Heisel, I noticed on this pretrial intervention contract, there's no signature in the witness field. Do you want that to be witnessed?
Judge, we have no preference on that. That's the court's preference. If the judge is signing it and we are signing it, that's good enough for us.
Okay. All right, Ms. Lay, if you will, raise your right hand. I'm going to place you under oath. Ms. Lay, do you swear that the testimony you give to the court will be the truth, the whole truth, and nothing but the truth, so help you God? All right, you may put your hand down. Ms. Lay, you are Katie Michelle Lay, is that correct? And bailiff, will you adjust that microphone for her? There we go, that's better. All right, and Ms. Lay, a couple questions. Are you a United States citizen? Do you read, write, and speak English? Have you ever been diagnosed with any type of mental condition? In this case, you're represented by your attorney, Miss Amanda Payne. Are you pleased with her representation of you? You feel like you've had sufficient time to talk to her about your case and have all of your legal questions answered? Is there anything about this pretrial intervention contract that you do not understand? And Ms. Payne, do you believe that Ms. Lay is competent today?
I do.
And you believe that she understands the nature and consequences involved with the risk associated with this pretrial intervention contract?
Yes, I do.
Ms. Lay, I see within this contract that you are waiving several important constitutional rights, one of them being the waiver of your right to jury trial. Do you understand that by requesting the court to waive your right to jury trial, you understand that once you waive that right, there's only very limited circumstances that your right to jury trial could be restored to you? You understand that? And by waiving your right to jury trial and stipulating that the evidence in this contract, you would be waiving the right to present your case to a jury of your peers. You'd be waiving the right to confront the state's witnesses and confront any evidence, cross-examine any evidence they bring against you in a trial before a jury of your peers. You understand that? And you understand that no one can take your right of jury trial away from you, but you can waive it if you do so of your own free will and accord, meaning you do it intentionally, knowingly, and voluntarily. Is that what you're doing today? No one's threatened or forced you to sign this document? And the court will note that Ms. Payne, counsel for the defendant and the state, has joined in on the defendant's waiver of jury trial. The court hereby approves the defendant's waiver of jury trial. Ms. Lay, you're also waiving your right to a speedy trial, and you're giving up certain rights with regards to the expunction of your criminal records. Do you understand that by waiving your right to speedy trial, you do not have the right to come in and ask the court to give you a speedy trial if you were to violate this contract? You understand that? And with regard to expunction of your records, if you successfully complete the program, certain criminal records of yours would be expunged from your criminal history. However, certain records would not. Specifically, the records of the Van Zandt County DA's office and the Van Zandt County Community Supervision and Corrections Department office, the probation department. Those two agencies would still maintain records on you, even though you've successfully completed and you have it erased from your arrest record with the arresting agency and the clerk and the court. You understand that? All right. And you understand that by waiving those rights, those are not going to be restored to you. Okay. And it appears that this contract is for a period of 2 years for the offense of criminal mischief, $2,500 to $30,000 of state jail felony. Is that correct, Ms. Payne?
That is correct, Your Honor.
And Ms. Lay, finally, do you understand that if you violate the terms and conditions of your pretrial intervention contract, then what could occur is the state could file a motion to put you back on the court's docket. And at that time, we could move directly to a bench trial. You understand that? And the court could determine whether or not you are guilty or not guilty. And the court would be able to consider the evidence that you've agreed for the court to consider. You understand that? Okay. All right, then the court is going to find that Katie Michelle Lee has intentionally, knowingly, and voluntarily waived the constitutional rights associated with the pretrial intervention contract. With the advice of counsel, the court hereby approves the placement of Ms. Lay into the pretrial intervention program. All right, Ms. Lay, I'm gonna have you report to the probation department and they'll give you further instructions, okay? You may. Mhm. Yes, ma'am, you may.
Thank you.
Ready on. Get you here. Ms. Alamka? All right, Ms. Alamka is set for arraignment today. Mr. Meany, are you prepared to proceed?
We are, Judge. Ms. Wellington has been made aware of indictment. She looked over it, named herself correctly. She understands the charge. Against her range of punishment. At this time, she's speaking not guilty on verdict.
All right, court hereby enters Ms. Alamka's plea of not guilty into the record and sets pre-trial for October 20th.
And Judge, if I may, we had previously discussed the 13th state camp.
Okay. That's available if you need that date. I think I set you earlier on the 20th. Is the 13th better for Ms. Alamka? I think 20th would be better because I think we reset a lot for the 13th yesterday or 2 days ago. Yes, and let me make sure. Okay, so Ms. Alamka, have you signed your pretrial release papers? Let's go ahead and have her see the probation department and check on the status of the pretrial release conditions. Okay, yeah, go ahead and step in the back right there and see Officer Mature. Tell you need to check on your pretrial release papers. Yeah. You didn't say nothing, bro. That's all right. I'll deal with you later.
Yeah, no.
Where are these papers going after they go with you? Okay. Okay. I don't think those were done today. So, I already did that. She was just released yesterday, so. What Mr. Manning said. Mr. Kohler. Cause number CR 2172. Mr. Kohler, the court has reviewed your application for an attorney, has approved it, and has appointed the Honorable Shrobnesh Murleader to represent you. I'm going to have the bailiff provide you with an order that has his name and address and phone number on it. In addition, we're going to reset your case for arraignment on October 15th. Once you get your notice, you'll be free to go. And within maybe a couple days, I need you to contact Mr. Murleader to discuss your case with him, okay? It may take a day or two before he realizes he's appointed to your case, but he's going to receive the paperwork, okay? Here you go. Same time, and he can keep that in the yellow copy. It's okay. Absolutely, absolutely. Yeah, I heard your staff's in trouble, so I feel bad for him. Yeah, I think you're maybe the last attorney or one of them, so you got time. You got time. All right, Mr. Kohler, you have signed have you signed your conditions of pretrial release yet? Okay, come on back here and have a seat right here in the jury box. We'll have you fill out some additional paperwork and then you'll be free to go. Ms. Rosales, this is Mr. Kohler. October 15th. This is CR 2191, Priscilla Rosales. Ms. Rosales, the court has appointed the Honorable Kurt Knoll to represent you. I'm going to give you a copy of an order with his name and phone number on it. Within 48 hours, you should contact him, let him know that he's been appointed to your case. The court will send him the same paperwork. We're going to reset your case for arraignment on October 15th. Oh, yes, I'm sorry. All right, Ms. Rosales, I need you to report to the pretrial release department before you leave. So you can come back here and she'll exit out this other way. So you can meet her in the hallway. Ms. Laredo or Mr. Laredo. right, Mr. Laredo has been appointed an attorney, Mr. Richard Schmidt. Go ahead and tell him that. I'm going to give him paperwork with Mr. Schmidt's name and phone number. He should contact him in a couple of days to start talking about his case. And we're going to have Mr. Laredo come back on October 15th for arraignment. The bailiff's going to give him a piece of paper here with that date on there for him to sign. Sorry. And then we'll have Mr. Laredo come over and have a seat. There's more paperwork we need to have him fill out in the back. And sir, can you just tell me your name? Thank you, sir. And are you related? Uncle? Okay, thank you, sir. Here, you just let them know we have a couple more out here so they know. Ms. Abney, I believe that you are viewing today's court hearing, and a moment ago, forgot to turn on the camera and the audio. Regarding docket CR 2169, State versus Roderick Hunter. Mr. Hunter was appointed attorney, Ms. Ann Thompson, and was set for arraignment on October 15th at 9 a.m. Court also appointed Bill Stevens to represent Eric Atkinson in CR 2147 and set his case for arraignment also on October 15th. Those are the only two. Mr. Chad Thomas. This is CR 2197. Mr. Thomas, the court has approved your request for attorney, has appointed the Honorable Jeff Wood to represent you. I'm going to have you fill out a notice of resetting to October 15th at 9 a.m. Court's also going to give you this order that has Mr. Wood's contact information on it. Contact him within a couple of days. After you receive these two pieces of paper, come over here and have a seat, and I'm going to have you fill out your conditions of pretrial release. No can do, sir. No can do. No, this is not a JP court or a city court. This is felony offense. You'll need to speak with your attorney. Is it Xavier Alexander Pitts here? If you want to go call his name, let's see. We have Mr. Pitts. And I believe that's, and Mr. Grubbs. Let's see if Mr. Grubbs is here. I don't think he is. Mr. Grubbs, you're Justin Grubbs? Okay, never mind. You have a seat. Jesse Henry. Maybe ask Mr. Ashmore. You can check with Mr. Ashmore to see if Mr. Henry's outside anywhere with him.
Yes, sir.
And I think that's it. That's all that I show. You show anything different?
Kenneth Ray Stanley. He said that she filed a paper, but it didn't approve.
Oh, is that Ms. Melantree?
Yes, sir.
Yes, they've got the waiver filed, and Mr. Stanley is set pretrial on October 13th.
So he's- All right, Mr. I'll check with Mr. Ashmore and then I'll call you.
Thank you, ma'am. right, Ms. Heisel, I'm going to stand in recess and give Mr. Ashmore a few more minutes. I think he is still speaking with, he's been appointed to Ms. Tanya McBride in CR 20135. And he's still speaking to I think Mr. Davis has been spoken to. Mr. Grubbs is here. And I believe Ms. Hicks is here. So I'm going to stand in recess, give him a little bit more time to talk. Well, I say that. All right. Yeah, he's going to talk to Mr. Grubbs now. I'm going to do some nice eyes and then stand in recess. No response.
No response to either name, Your Honor.
All right, the court having called CR 289, State of Texas versus Xavier Pitts. Court also having called CR 2168, State versus Jesse Wagner Henry. Neither have appeared in the court today. Their names have been called loudly, distinctly 3 times at the courthouse with no response. Court hereby issues a judgment nisi and alias capias for their rearrest. All right, the court's going to stand in recess until Mr. Ashmore is ready to proceed on his clients. All right, the court is finished with its recess as Mr. Ashmore is ready to proceed on his cases. Ms. Heisler. Be just one moment, Mr. Ashmore. Ms. Heisel's on her way back.
I only made you wait 55 minutes. It's only fair.
I won't do the same to you.
I'm really sorry.
I won't do the same to you.
It's not a call you ever want to get.
No, but I imagine it's easy to get those calls having to be multiple jurisdictions and everyone competing for the same time slots.
Well, we had it on the calendar and we took it off the calendar. It's clear that we should have done step 2 of that.
But you're here though.
Yeah.
It's better that that happens and you're still here than, yeah, we took it off the calendar and we're not coming.
I don't think that's fair to the clients or the employees.
Yeah, it happens though. Let's see, are you ready on, I believe you received a new appointment today, is that correct?
Yes.
That's Ms. McBride.
Yes.
All right, Ms. McBride, if you'll make your way to the podium. This is CR 2135, State versus Tanya Lucretia McBride, set for arraignment today. Have you had an opportunity to review the indictment with your client?
I have, Your Honor.
Are you ready for arraignment?
I am, Your Honor.
You may proceed.
Ms. McBride, you and I met, just a few months ago. Again, I apologize to you for being late. It's not my practice, it's bad first impression. I've explained to you the nature of the charges, as set out in the indictment. And you have confirmed that your name is spelled correctly? Yes, sir. Okay. And you understand the nature of those charges? And you're gonna enter a not guilty today? Yes, sir. And we're gonna ask for pre-trial. You understand this notice that I hand will be the only notice you get of the next setting?
All right, court hereby enters Ms. McBride's plea of not guilty into the record and sets pre-trial. Are you available on October 20th, Mr. Ashmore? 15th or the 20th? All right, court sets Ms. McBride for pretrial on October 15th at 9 a.m. Mr. Ashmore, did Ms. Abraham give you any conditions of pretrial release for Ms. McBride?
She did not.
Okay.
And I think that's because it's a brand new.
Yes. Yeah, just go ahead and have a seat, and we're going to have some conditions of pretrial release for you to sign that are associated with Mr. Ashmore's appointment in this case, okay? Who are you ready on next, Mr. Ashmore? Ms. Hicks? CR 20123. We're also set for arraignment today.
We are, Your Honor. And Ms. Hicks, we met out in the hallway. We've spoken, you and our office have spoken a few times back prior to that. And we looked at digitized image of your life. And you confirmed your name spelled correctly on it? Okay, so it needs to be corrected to R-A-C-H. You understand the nature of the charge against you, and you're not guilty today. You understand this reset, you the only notice of our next court set. And I asked the court to set it at the same time as the prior, October 15th to 9.
Okay. Is there any motion by the state?
Your Honor, we would make an oral motion to amend the indictment by interlineation. And just for our records, I had a hard time hearing. Can I get that spelling one more time?
I believe it's R-A-C-H-A-E-L. Any objection to the motion to amend the indictment?
No, Your Honor.
All right, court hereby grants the amendment to the indictment to correct the spelling of the first name of the defendant to R-A-C-H-A-E-L, Rachel Leanne Hicks. And the court will set this for pretrial on October 15th at 9 a.m.
That all should be my plan of excuse, Your Honor.
Ms. Higgs, have you signed your conditions of pretrial release yet? Come over here and once you get your notice, come over here and have a seat, and the probation department will speak to you about that. Who's next, Mr. Ashmore?
Mr. Rhodes is ready to cover.
CR 2164, State versus Justin Richard Grubbs. You ready for arraignment, Mr. Ashmore?
Yes.
Go ahead, sir.
Mr. Rhodes, you and I had this week, a few moments ago, and I explained to you that, in fact, just about an hour ago, the district attorney's office shared your discovery file with us, and we looked at the indictment. A bad copy of a petition that you were able to identify your name and it's spelled correctly. You understand the nature of the allegation you're entering, you're not guilty. Okay. And you understand this notice will be the only notice you receive of the next court set. And I'm gonna ask the court again, say 8:15, 9 a.m.
Court will set pretrial for October 15th at 9 a.m. and will enter Mr. Justin Grubb's plea of not guilty into the record.
For housekeeping, have you met with the adult probation department?
Okay.
You're a judge, you'll probably do so.
Yeah, just come over and have a seat and they'll discuss the conditions of pretrial release with you.
All right, and then we have just one left, Your Honor, and that's Mr. Davis.
Mr. Davis? This is CR 20-155, State versus John Robert Davis. Go ahead, Mr. Ashmore.
Mr. Davis, you and I had a chance to meet in the hallway, and we've spoken previously, although it's been some time, about your case. And we looked at a digitized image of your indictment, and you confirmed your name is spelled correctly. And you understand the nature of the charges against you, and you want to enter a plea of not guilty today. And you understand that this form will be the only notice of the next hearing. And we're going to ask the court again, October 15th at 9 a.m.
Court will set Mr. Davis then for pretrial on October 15th at 9 a.m. and hereby enters his plea of not guilty into the record.
And have a chance for him to sign and put his address on there. So I think the judge, he needs to do the same thing.
Yes, just Mr. Davis, once you get your notice there, the yellow copy, come over here and have a seat here next to Mr. Grubbs, spread out. And then the probation department will discuss your pretrial release conditions with you, and then you'll be free to go.
Judge, we have one other client here today, but he's not in the hallway. I've asked my office to call his home address before I'm excused. Could I step out of the hallway and see if we've been able to reach him?
Yes, is that on Mr. Jesse Henry?
Yeah.
Yes, go ahead. Ms. Heisel, there's going to be an update on one of our NICIs, Jesse Wagner Henry, CR 20168, Mr. Ashmore's client. Court was reviewing the notice that we sent, and the address that we sent was incorrect.
Okay.
We're not going to NICI him. Rather, we're going to set him for an arraignment on October 15th at 9 a.m. And so bailiff, I'll need you to withdraw your bailiff certificate. Excellent, excellent. And let's go ahead and let me double check Xavier Pitts just while we're at it. He should add his. If he's been here 3 times, that'll make it easier. Nine 1720. Yeah, so Mr. Pitts, nice size, good.
And Judge, did you put an amount on that nice eye?
If Miss Abney's going to prepare it, then yes, let's do 100,000 on Mr. Pitts. And that'll be the only one since Henry's being withdrawn. I'm going to stop the recording at this time.